There is no surer sign of decay in a country than to see the rights of men held in contempt. Contempt, the Inibehe's case. Effiong had a pending motion before the court asking Your Lordship, the Chief Judge of Akwa Ibom State, Justice Ekaite Obot, to recuse herself from the case on the likelihood that her demeanor and or posture over the matter under reference may prevent him from getting justice. The court, instead of hearing the motion, to rule on it so her ruling can be on record, she overlooked the motion and proceeded with trial. Effiong further raised an objection questioning why armed policemen were allowed into the courtroom while proceedings were ongoing. The judge took offense on the issue, adding that Effiong had disrespected her repeatedly in the course of the case despite her several cautions. She thereafter charged him for contempt in Fashe, Korea, wherein she committed him to 1 month imprisonment. While it is the law that the power to commit an individual to prison for contempt lies in the court, it is important to interrogate what amounts to or constitute contempt of court in the eyes of the law and the circumstances under which the judge should commit a person to prison. There's a clear distinction between conduct likely to obstruct the course of justice or conduct likely to bring the court to disrepute, and acts or conduct exhibited by a counsel that merely annoys the judge. The former is outright contempt, while the latter, though disrespectful, cannot be qualified as contempt of court. Lord Tukur at the Privy Council in Joseph Izura versus the Queen, the court opined that it is not every act of discourtesy to the court by counsel that amounts to contempt, nor any conduct which involves a breach of counsel's duty to his clients. In the present case, the appellant conduct was clearly discourteous. It may have been a breach of the rules, and it may perhaps have been a dereliction of the duty to his client. But in their lordship opinion, it cannot properly be placed over the line that divides a mere discourteous act from contempt. It is the court's view in the foregoing case that contempt of court and the actual committal to prison of a counsel is not to be invoked at the slightest provocation, that this may constitute an abuse of court process and its orders. The bar exists to protect society and its inhabitants from criminal invasion and civil wrong, and that should remain the primary objective of the court. We must not forget that counsel committed to prison for contempt has a right to appeal, and the appellate court may overrule the lower court where it discovers that the court of first instance acted in error, which led to the miscarriage of justice. In the case of Adeyemi Kande Johnson against Mrs. Esther Edigi, the contemnor insisted his submission before the magistrate be on record, and same was misinterpreted by the magistrate as contemptuous when she put a question to the contemnor who declined giving answers to the question. The appellate court condemned the decision of the court of first instance on the ground that such does not amount to contempt of courts. In Effiong's case, it is important that the NBA and all relevant authority wade into this matter and ensure that he gets bail pending appeal, so that the appellate court can look at the decision of the court of first instance and decide whether or not there was contempt of courts. In my opinion, I think, and in the opinion of many jurists, that committal to prison on the basis of contempt of court should be used sparingly and not at any time, because this will amount to abuse of court process. I shall go to Rabbi again.